So welcome back to week 2 of civil litigation, and basically today I pick a motivation from Nelson Mandela, and Nelson Mandela stated that faith is the ability to see the invisible, believe in the impossible, and trust in the unknown. So Nelson Mandela was one of the most distinguished lawyers and politician that the African continent has ever been blessed with. So let me hope that that motivation will be able to take us through the civil litigation week. So basically here we are looking at the introduction. This will be the second week of civil litigation in term 1. During the week, students will be exposed to procedures subsequent the institution of suits prior to their hearing. So by the end of this module, you will be able to 1. Explain processes subsequent to service of summons. So I think service of summons is governed by Order 5 of the Civil Procedure Rules, and we know that when you look at Order 5, Rule 16, they provide for filing of an affidavit of service. After having served summons, you have to file what we call an affidavit of service. Then it illustrates the filing of defenses and reprise to the defenses. So the rules basically governing defenses, you are going to look at Order 8, and Order 9 of the Civil Procedure Rules, and basically Order 8, Rule 2 provides that the defendant has to file within 15 days after you have been served. So then also Order 9 goes into details to discuss the rules governing how do you now file the defense. So you have to read Order 8 and Rule 9 together. Then from there we are going to look at illustrate the filing of defenses and reprise to the defense. So basically when you look at Order 9, it covers how do you file a defense, and of course the defense, you must pay the appropriate court fees also in filing the defense, and then it illustrates the application for default, interlocutory, and ex parte judgment. So when you talk about a default judgment is under Order 9 Rule 5, but the default judgment arises where you served the defendant, but then the defendant does not enter into a defense, and yet you served him, and the affidavit of service was also filed. So when you can prove that you served the defendant, you filed an affidavit of service, but then the defendant did not enter into a defense, then you go for what we call a default judgment. The interlocutory judgment, on the other hand, is when there is a liquidated sum. When there is a liquidated sum, and then which is not being contended, the courts can enter into an interlocutory judgment and then set the other amount for proof. So when a matter has a liquidated sum, then the court can enter what we call an interlocutory judgment. So then also here we have ex parte judgments. Ex parte judgments arises where one party has not a party entered into a defense, a party filed a defense settlement of defense, but then he does not enter appearance. So that's when we have an ex parte judgment. But basically when you read Order 8 and Order 9 of the CPR in detail, you'll have to understand these judgments and when they arise, because that will make our next task easier for you. So that's how briefly I can explain them, but you can also go and look at the rules and also case law, so as you can better understand those judgments. It illustrates the process of taking out summons for the elections. So summons for the elections are under Order 11. Order 11, I think, in the amendment. And basically, summons for the elections, it's a procedure whereby you are seeking guidance from court on how you're going to go about the matter. So basically, the registrar directs you on how the matter is supposed to be conducted, but you supposed to read Order 11 of the amendment, then you are going to understand summons for directions. But always when a matter is brought by a plaintiff, then you seek summons for directions. And basically, like the way I've said, you, the register is directing you on the quickest way of how the matter can be disposed. So in case there are some facts you are agreeing to, then they can come to that and see agreed facts and disagreed facts. So draft relevant documents in relation to the processes subsequent to service of summons. We talked about you can have an affidavit of service. Then recognize the issues relating to processes subsequent to service of summons. So you should of course serve in time, and also the filings should also be done within the stipulated periods. So workshop 1, the workshop covers principles regarding service and non-service of process within the stipulated period, obtaining uncontested judgments or stroke decrees, where the defendant or respondent fails to take an essential step after receipt of effective service, defenses, reprise, and answers pleadings consequent to filing of suits. So by the end of the workshop, students should be able to 1. Explain processes subsequent to service of summons, illustrate the filing of defenses and reprise for defenses, illustrate the applications for default, interlocutory, and expert judgments, draft relevant documents in relation to processes subsequent to service of summons, then recognize the issues relating to processes subsequent to service of summons. So part A, assume you are a head legal department UCDA, the managing director Mr. Kagugube Andrew brought you documents annexed A to F. He informed you that they were brought to his office on the 11th day of October 2024 by law clerk Anita from MSR and M advocates. He signed and dated copies returned to the said law clerk. He informed you that he forgot to hand over the documents to you for action before he went on annual leave. The following day, he returned office 2 days ago and has handed them over to you for action. Advise Mr. Kagugube Andrew on the steps to take to defend UCDA in the matter. So basically here, when you look at order 8 rule 2, they say that written statement of defense must be entered within 15 days. So basically here, the 15 days have already elapsed. So basically what you do is you have to seek leave. You have to seek leave to file a defense out of time. And the procedure is by notice of motion supported by an affidavit. So those are the documents we are going to do what? To draft in task A1, but we are seeking leave to file out of time. When you read order 8 rule 2, they say upon you showing sufficient cause, then the court can allow you to file a defense out of time. Then part B, assume you are a legal assistant at MSR and M advocates, and you checked on IKIMIS system of the High Court Commercial Division on 30th October 2024 and found that since the service of the plaintiff on UCDA, it has not taken any action. So advise on the possible ways of proceeding with the matter while specifying the most appropriate in the circumstances. So basically here you look at several options. For example, you obtaining an expert judgment, and we see that an expert judgment arises whereby one person files a defense, but then he does not enter appearance. And then we talked about interlocutory judgment. Interlocutory judgment is where there is a liquidated sum. So where there is a liquidated sum and the other sum is being contested, the court can also enter into an interlocutory judgment for the liquidated sum. Then also looked at default judgment. So a default judgment arises where the defendant fails to enter into a defense. So where a defendant does not enter into a defense and you prove that you served the summons, then you can now seek court. You can apply the registrar to enter what we call a default judgment. So draft the necessary document here. So basically the necessary documents, we are going to apply to court to enter what we call a default judgment under order 9 rule 5. So we are going to apply for a default judgment. So part C, assume the summons were served on 21st of October 2024. The managing director wants you to defend the matter. He informs you in view of an extra if UCDA is willing to pay half of the claim. So basically here, this means that we are going to enter into a written statement of defense, because now the 21st October, that means we are still within the 15 days required by Order 802. So that means we have to draft a written statement of defense. We have to draft a written statement of defense, and basically contending that we only want to pay half. So you have to look at the plaint, which was also annexed, because remember here we are replying to the plaint. We can deny some of the paragraphs and specifically bring out the intention of our client, which is to pay half. So then part D, assuming you're a lawyer for MSLM advocates and a defense was filed indicating that UCDA is ready to pay 50% of non-suitor's claim. So illustrate the steps and action you will take to protect your client's interest and draft the necessary documents. So basically here, if now the lawyer of the defendants are agreeing that they want to pay 50%, and of course you know that your client now wants full percent. So what would you advise your client who is non-suitor? For example, here there are a lot of options. One, we have the option, can we enter into a consent judgment? Because a consent judgment, that means if they are agreeing part, that means we can go for a consent judgment for that part of the claim they want to pay. But also I'm also still looking at the interlocutory judgment, because if some of the money is uncontested, can we apply for an interlocutory judgment on that part, and then we set the contested part for strict proof? So basically those are the options I'm still contemplating in part D, whether I should go for a consent judgment or whether I can apply for an interlocutory judgment, and then the liquidated sum which is not contested, I get an interlocutory judgment on that, and then the other contested amount we go for strict proof. So that's what I'm also still considering. So assume that plaintiff took action and obtained a judgment in task 2. So basically here we are task 2. If the plaintiff obtained a default judgment, basically here we would be looking at how do you set aside a default judgment. And you can only set aside a default judgment if you prove that one, you are not served summons. So if you can prove that you are not served summons, then a default judgment can be set aside, or maybe if you can show any other sufficient cause. But basically here in part B, assume that the plaintiff took action and obtained a judgment in task 2, we are basically looking at illustrate the process of protecting the UCDA interest. So that we can only protect UCDA interest by doing what? By setting aside the default judgment. So basically that is it for workshop 1. Very brief indeed, but it has a lot of thinking to be done. So it's not as simple as it looks, because it has a lot of complex issues. So you have to first make sure that you understand, then that's when you can discuss. But in case you want to join us, we have a mentorship group where we have Saturday discussions on Saturday and Sundays, and then we have summarized notes which are always of high quality and issued in time. So please, you can consider to be part of us, and we shall be happy to work with you. So we are going to workshop number 2. So they are saying that this covers principles regarding obtaining orders for inspection of documents, discovery of documents, interrogatories, amendment of pleadings, and summons for direction. So basically, when you talk about inspection of documents, these ones are under order. These ones are under order. These ones are under order 10. Order 10 of the CPR. I think order 10 of the CPR is one which provides for inspections, interrogatories, as well as discoveries. So basically, when you look at this order, it gives you how do you proceed, in the instant circumstances. But when we talk about discovery of documents, it arises in instances whereby you find that you want a document, but it's in the hands of a third party. So the only way you can do that is when you seek court that they order that person to bring that document. So that's what we call discovery of documents. Interrogatories is when you have specific questions you would want to ask that person. So that's when you will proceed under interrogatories. Also, there is a procedure under order 10 where you can also, if you want to ask questions from a person on oath, then you can go for interrogatories. Then amendment of pleadings. Amendment of pleadings is under order 6 through 19, which basically gives you the procedure of how do you amend pleadings. And when I see on order 6 through 19, they say that the court may at any stage of the proceedings allow either party to alter or amend his or her pleadings in such manner and in such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. So basically here, they are provide for you have to seek leave, but 20, plaintiff may amend without leave. A plaintiff may without leave amend his or her plaint once at any time within 21 days from the date of issue of summons the defendant, or where a written statement of defense is filed, then within 14 days from the filing of the written statement of defense or the last of such written statement. So basically, 20, a plaintiff may without leave amend his or her plaint once at any time within 21 days. So Rule 20 provides that if it is still within 21 days, the plaintiff can still amend the pleadings, and the defendant within 15 days. So we are still looking at interrogatories, and we say that interrogatories are under order 10. So basically, when I look at order 10, so basically order 10 provides for interrogatories. It provides, so order 10 rule 1, discovery of interrogatories. So in any suit, the plaintiff or defendant may apply to court within 21 days from the date of the last reply or rejoinder referred in order of these rules for leave to deliver interrogatories and discoveries in writing for examination of the opposite parties. So basically those are interrogatories. You want to ask questions to the opposite party, and it's always on oath. Then discovery of documents. I have said that when the document is in the hands of the other party, then you can seek court to do what? To force that party to bring that document. Then summons for the elections. We talked about summons for the elections, and we said that they are in order 11 of the amendment, which provides for summons for the elections. And they say that any person, the court shall, for purpose of preparing for every action which this rule applies, provide an occasion for consideration of a suit for a scheduling conference and trial for the suit, so that any matter which should have been dealt with by an interlocutory application and has not been dealt with may, so far as possible, be dealt with. So direction may be given for the future course of action as appears best to be adapted to ensure just, expeditious, and economical disposal of the matter. So basically here the court is just giving guidelines on how the matter can be disposed of first. So I hope you have understood those terms. It has said the process of taking out summons for directions. Yes, we have looked at that, draft the relevant documents, and recognize the ISCO issues. So part A, using the facts in workshop 1, UCDA filed its defense in which it states as follows. Following the surprise by the various nursery operators, it carried out a field verification in 2023. The report of the field verification committee showed that some farmers did not receive any seedlings. There was no coffee growing in the field, and that in some cases there was duplication of names. In some cases, the farmers did not have their national identification numbers reflected. As a result of the above, UCDA could only pay for what was verified in the field. So this report was not attached to the defense. You have made efforts to access the said report, but UCD has refused to avail the same to you. So as counsel for the plaintiff, I the process of obtaining the said verification report. So basically here it's for discovery of documents, and the procedure, when you look at order 10, it's by chamber summons supported by an affidavit. So basically that would be the procedure. Just look at order 10. Order 10 basically gives you the procedure to do that, and it's by chamber summons and an affidavit in support. Then also part B, assume as counsel for the plaintiff, your client informs you that there was other supplies that were not included in the claim. He avails Annex G and H. This was 21 days after being served with the defense by UCDA. Advise the plaintiff on the process to ensure that these annexures form part of the claim. So draft the necessary documents. So basically here we are looking at how do you amendment of pleadings, and if it's above 21 days, we have said order 6 rule 19 and 20 provides that if they are above 21 days, you have to seek leave. So since that order 6 does not give us the procedure, then we are going to invoke order 52 of the CPR, and we proceed by notice of motion supported by an affidavit. We are going to proceed by a notice of motion supported by an affidavit. Then advise the plaintiff supposed to ensure that the annexures form part of the claim. So that's it. I think we are done with that. Then part C, assume further that all parties to the civil suit have conclusively filed and exchanged their respective pleadings, illustrates as subsequent pretrial proceedings. So basically here what we are going to do is to go for summons for the elections under order 11A. So summons for the elections under 11A, and then after that, after the memorandum conferencing, of course memorandum conferencing, then summons for the elections, then after the summons for the elections, draft an application seeking for the elections demanded appropriate. So basically it's there in the amendment. It's form 14, but it's there in the amendment. You can look at it. In the amendment provides that form of summons for the elections. So that's the document we're going to draw there. So that's it for workshop 2. Please, in case you want detailed discussion to this workshop, you can join us in our mentorship group. Members pay 100,000 per month to support our services, our research, because we do a lot of researches, we summarize cases, a lot of things is done. So but it's really worth it, if it can fit your budget. If it cannot fit your budget, then I understand. So basically that is it. We go to workshop 3. So they are saying the workshop 3 The facts in workshop 2 task 3 will be used. By the end of this workshop, we'll be able to 1. Explain the processes subsequent to service of summons. So basically we do that because after serving summons, you have to draft an affidavit of service, and I don't know whether I have drafted an affidavit of service before. Yes, but that's what's basically done. Then illustrate the process of taking out summons for the elections. We have to look at order 11 of the amendment, because it has all those processes: draft relevant document solution processes subsequent service of summons, like an affidavit of service here. Then recognize ISCO issues relating to the processes. So ISCO issues include not overcharging clients, serving in time, all those things. So areas to guide your research. Of course, we have the law applicable there, and then we have the annexures. We have summons to file a defense. We have the plaint. So this plaint is very well drafted. In case the plaint in your book is not well drafted, you can copy this, because you see how the particulars for special damages. You know, when you're suing for special damages, you must plead and prove them. They must be strictly pleaded and proved. And also general damages, special and general damages. So this is a very good plaint. If you don't have a good plaint in your book, you can adopt this one, and then you use this one, and also what they are asking from court. But this is a very good plaint, so you can adopt it in your book, because in the exam they always ask for the plaint. So annexure A, coffee nursery. We have annexure A, which is about coffee nursery. We have annexure B. I think it has a list of planting season allocation of seedlings to suppliers. Then we have annexure C. Annexure C, I think it's not clearly visible, but it seems it's kind of a receipt. Name of the operator, Uganda Coffee Development Authority, request suit supply. I think this was a request form, something like that. Then we have also here, I think this one is terms and conditions of this order. It's also an order. Then annexure D. Annexure D is coffee delivery. It's a delivery form. Delivery and distribution form. It's a delivery and distribution form. Then we also have development, coffee plant, delivery and distribution form. We have annexure E. So those annexures, you should look at them. Annexure F, acknowledgement of receipt. We have an acknowledgement of receipt. I think this annexure F is referred to in our facts. Then annexure G. Annexure G is notice of intended suit. Notice of intended suit. So basically, you should refer to these annexures. Then we also have a summary of evidence. And of course that's it. So basically that is it for civil litigation week 2. It has been it's not too wide, but it's very tricky. If you don't understand civil procedure, it's very easy to be confused. So try to internalize and make sure that you read the CPR and you understand it. So where you are confused, go back to the law. You know, the law is like the word. You know, Jesus said that man shall not depend on bread alone. So whenever you are confused by maybe your classmates or the PAs, when you reach in your room at night, go back and open your civil procedure rules and look at it. Look at that rule and read the whole of it. I'm telling you, I was also confused at some time, but I started reading the rules, but I started to get some clarity. So when you don't understand civil procedure as a whole, you will tend to be confused. But the only solution I can give to you is just to go and open your civil procedure rules and then read the rules. And when you are still confused, read the cases. But the civil procedure rules is always adequate, it's always sufficient on its own. So when you read it, most of the clarifications are going to be solved. So that is it for today. I wish you a blessed week. It was as simple as that and not as hard. Thank you.